Okay, we're live again in 5, 4, 3.
We're back with our Constitution Day special, Constitutional Crossfire, and my honored guest, Mr. S.A. Knight, a litigator who's seen more than his fair share of high-profile cases in his storied career.
Well, you know, Shirley, I think I've just been at the right place at the right time.
I'm sure it's more than just a matter of luck. You have a reputation for being one of the most successful attorneys since Perry Mason and one of the nation's foremost specialists in constitutional issues.
Well, Shirley, the Constitution of the United States is one of the most remarkable documents in the world, setting up rights and responsibilities unparalleled in any other society on earth.
Thanks to the Constitution, everyone here in America gets their day in court.
Well, that's true, Shirley, but the right to a jury trial is not just an American invention. Oh, sure, it's guaranteed by the Sixth Amendment of our Constitution, but the concept has been traced back to the Magna Carta.
Very impressive. I'm told that's one of the secrets to your success. You always come prepared. But today, we're more interested in recent history, your history. Tell me about that very first big high-profile case, the case that launched your career.
My first big case? Well, I thought we were here to talk about the Constitution of the United States and really not about me.
Your career and the Constitution seem to have gone hand in hand. Tell us about that first big case, and I'm sure the constitutional issues will come out as well.
Well, now, you know, it's never difficult to get an attorney to talk about himself. My first big case, huh? Well, some called it the trial of the century. But at that time, the government tried to hush it up for national security concerns. Ever hear of People versus Goldilocks?
You were the defense attorney in People versus Goldilocks?
I almost wasn't. I was fresh out of law school and junior in the public defender's office. Even though I was barely one step out of the mailroom, my ambition was as big as the state of California. As you know, the arrest made national headlines. Now, of course, Miss Locks had the constitutional right to counsel, the Sixth Amendment to the rescue again. No one has to face prosecution alone. Well, I don't know if it was fate, luck, or accident, but the court appointed me as Miss Locks' public defender in this case because she couldn't afford to hire her own attorney.
Ladies and gentlemen of the jury, I want you to remember that through the protections of the Constitution in our American legal system, the defendant is presumed innocent until you find otherwise. Just because she has been arrested does not mean that she is necessarily guilty of any criminal wrongdoing. The prosecution has the burden of proving every element of the charge against her. This is the highest burden, which is called beyond a reasonable doubt. This is the highest burden we have in our law. And if the state fails to do so, you must acquit. Ladies and gentlemen, let me read to you the charge that faces Ms. Locks. Ms. Locks is charged with 1 count of felony burglary, the unlawful entering of another's residence with an intent to take property from the owner.
So what really happened? Did she do it?
You know better than to ask an attorney that question. But I will give you the facts of the case. It started as a simple charge of trespassing.
What are you doing back out here? All right, we'll send the party out back.
But quickly escalated into a felony burglary case when they found the bear's cell phone in her bag. From the very beginning, Goldie maintained that she became lost while on a Girl Rangers event.
So you were caught inside the house?
I'm telling you, I was lost. I was with my Girl Ranger troop. We were doing a conservation project, cleaning up the forest, and somehow we got separated. I was just looking for some help.
We found the cell phone in your pocket. You were in the house. Fingerprints everywhere.
No.
We have the evidence.
I was just hot and tired and thirsty. I was really afraid.
Of course, wouldn't you know it, the house just happened to belong to the Bear family.
This porridge is too hot. Oh, this porridge is too cold. Ah, this one is just right.
She was found asleep on the child's bed, the cell phone in her bag. Well, the poor girl was just lost and hungry and trying to call for help, but the press blew it all out of proportion. Some reports say she was drunk or on drugs. The police found her fingerprints everywhere, her DNA on the spoons, hair and fiber evidence on the chairs, and her perfume residue on the beds, and of course that cell phone in her bag. Looked like an open and shut case. If I didn't come up with an idea fast, Goldie was headed for a one-way ticket to the Crossbar Motel. There was so much pressure on the poor girl she even confessed. But in their hurry to get a quick conviction, the police forgot to read her Miranda rights.
Let the record reflect that the jury is not present in the courtroom. After receiving the evidence and hearing the argument, this court is prepared to rule. No Miranda warnings, Ms. Wolf? Very sloppy work. Miranda was designed to protect those in police custody, thus enforcing the Fifth Amendment right against self-incrimination. The police have a duty to inform the defendant that she does not have to say anything out of the presence of her attorney, and that anything she says may be used against her. At this time, the court is prepared to rule. The confession is inadmissible.
But, Your Honor.
But nothing, counsel. Next time, be better prepared. Court is now in recess.
Well, Miranda saved my bacon that day. The judge didn't allow Goldie's confession into evidence.
Wow. So what happened next?
Well, at first it was a total nightmare. The prosecutor was none other than B.B. Wolf, the biggest, baddest prosecutor in the state.
Wolf? Her record of convictions was nearly perfect.
Wolf was at the top of her game. She threw everything at us but the kitchen sink. She had witnesses, and believe me, they had no trouble identifying Goldie as the perp. She also had the forensic evidence, plenty of it. She was a machine. The term legal eagle was made for prosecutors like her.
How long have you been a Girl Ranger in this area?
Practically all my life.
And how long have you been a leader in the Girl Rangers?
4 years.
And in all your time as a loyal Girl Ranger and an esteemed Girl Rangers leader, have you ever known the defendant to be a member of your troop?
Never. That girl was never a part of our troop.
Let the record show that the witness is pointing out the defendant, Ms. Goldilocks.
Wolf was pressing hard. I knew she wanted nothing more than to get Goldie on the witness stand so she could tear her testimony to shreds. Fortunately, we were protected by her Fifth Amendment right not to testify at her own trial. It would have been grounds for a mistrial if she tried.
You are correct, Mr. Knight. The Constitution places the burden of proof on the state. Your client is not required to testify at her own trial if she chooses not to do so. She may rely on the state of the evidence. I will instruct the jury to disregard the fact that she has chosen not to testify. Ladies and gentlemen of the jury, the Fifth Amendment allows a criminal defendant to refuse to testify against herself at her trial. You are admonished to disregard...
Unlike other countries, the right not to testify at your own trial forces the prosecution to bring out independent evidence without the assistance of the accused. Fortunately, we had the right to confront and cross-examine all of the prosecution's witnesses. And believe me, I was a man on a mission.
So, you've been a Girl Ranger practically all your life.
Oh yes, I went from Sprout to Doe to Tracker to Eagle Eye, and I even won the Golden Compass Award before I became a leader.
And your Ranger troop is the only one in the area, yes?
Oh no, there are 4 or 5 here.
I see. But of course, you know all the other members of all the other troops, right?
Oh no, there are too many. I couldn't possibly know all.
You were saying you couldn't possibly know all the other girls in all the other troops. So would it be fair to say my client could actually be a Girl Ranger and you just don't know her?
Yes.
What was that? I can't hear you.
Yes.
Guess what?
Yes, Goldilocks could be a Girl Ranger.
Your Honor, the defense rests.
It truly was the trial of the century, all right. A battle of the titans, as we fought for the hearts and minds of that jury.
Miss Locks is not a victim of unfortunate circumstances, but rather an opportunist looking to gain from the property of others. The
Wolf was brilliant, but I was motivated. I was inspired. I was at the top of my game. When I got through with them, there wasn't a dry eye in the house.
The people have not proven their case. That is why you must come up with the verdict not guilty.
I had done my best. It was up to the jury now. Goldie's fate was in their hands. The jury only deliberated for 3 hours before they came back with the verdict.
Ladies and gentlemen of the jury, who is your foreperson?
Yes, Your Honor.
And do you have a verdict?
Yes, we do, Your Honor.
Ms. Locke, Mr. Knight, please rise.
What? What was the verdict?
The verdict? This is not about the verdict. Like I said at the beginning, the point is about the process, the procedure, and the constitutional issues.
The constitutional issues, right. Now, what was the verdict?
I know this is TV, Shirley, but that doesn't mean you can't think for yourself. Given the evidence of the case and the constitutional issues involved, what do you think the verdict should have been?